Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering DEI programs destroyed as conservatives strike back. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. Coming from the Washington Post, DEI programs toppled amid a surge of conservative lawsuits. A year after the Supreme Court struck down race-based college admissions, a new legal campaign is forcing public and private institutions to abandon racial preferences. Right-leaning public interest groups have filed a barrage of federal lawsuits intended to dismantle long-standing corporate and government programs that consider race in awarding jobs and other perks. And their litigation is already eroding the use of affirmative action in an array of American institutions. That is true. It's not all just recent DEI programs. It even goes back to as much as business contracts being offered through the government exclusively to certain races or certain genders. 1 year after the Supreme Court struck down race-based admissions at Harvard and other schools, court rulings have forced the removal of racial preferences from two major COVID relief programs, a federal contracting program that doles out $20 billion a year, and even the U.S. Minority Business Development Agency, a 55-year-old agency that was ordered in March 2024 to open its doors to all races. That also included getting contracts to people for their small business. So if you were a certain gender or a certain skin color, you'd have opportunities that other people would not have. That's been canceled. Meanwhile, private companies are acting preemptively, seeking to avoid litigation by terminating fellowships and executive bonus programs aimed at employing minorities. When they say these companies are acting proactively and they're trying to avoid lawsuits, these companies are very sophisticated. Even the most basic mid-level attorney understands this is not something that passes any legal standard. What you're doing is illegal and you need to stop it if you don't want to get sued. It's unending legal liability. Anyone who is being discriminated against has an excellent chance of winning a lawsuit. Quote, "The goal is complete race neutrality. That is the end goal of all this litigation," said Daniel Lennington, a lawyer for the Wisconsin Institute of Law and Liberty, also known as WILL. "It's a view of racial equality that we think is in line with the Declaration of Independence." Encouraged by the Supreme Court's conservative majority, WILL and other groups have filed more than 100 lawsuits since 2021, challenging racial preferences and other efforts to address demographic disparities in business, government, and education, according to a Washington Post tally based on news articles, law firm newsletters, and interviews. I see the same articles. There's a lot of lawsuits going on. Even more lawsuits are in the pipeline. Through social media, the conservative legal groups are urging anyone with a gripe about racial preferences to give them a call. But wherever you live, if you've been treated differently because of your race, contact us, according to Lennington, which he posted on Twitter. Another group, Color Us United, runs a DEI tip line from its website. And at America First Legal, former Trump advisor Stephen Miller warns in a promotional video that corporate policies, quote, "punish Americans for being white, Asian, or male," and advertises a toll-free number to call for legal advice. Quote, "If you or a loved one were denied a job, raise, promotion, or professional opportunity as a result of diversity quotas, equity mandates, affirmative action, or other racial preferences, we want to hear from you," Miller says. Fingers pointed at the camera, please call us. While cases of reverse discrimination have been brought in U.S. courts for years, the conservative campaign has been invigorated by the Supreme Court's ruling last June that race-based college admissions decisions at Harvard and the University of North Carolina violated the Constitution's guarantee of equal protection under the law. Recent victories in court, along with a rising volume of complaints filed in districts with conservative judges, suggest this wave of litigation could sustainably alter how American institutions handle issues of race. Even advocates of diversity programs acknowledge that some long-standing practices are endangered. Any organization that provides a palpable benefit to a person based on race, national origin, or sex now runs a potential legal risk, according to Kenji Yoshimo, a professor at New York University and the director of the Meltzer Center for Diversity, Inclusion, and Belonging. Under the current direction of the Supreme Court, Yoshino said it will be virtually always illegal for a government or private entity to use racial classifications for hiring, promotion, or other benefits. Other, more limited programs to promote diversity, such as anti-bias training and efforts to ensure fairness in hiring, will remain, he said, adding the Supreme Court is never going to complain about attempts to remove bias. So far, the conservative groups have won their most significant victories against the federal government. In addition to rulings against the Minority Business Development Agency and the COVID relief programs, a federal judge last year ordered changes in the U.S. Small Business Administration's program that offered preferences in contracting to socially disadvantaged individuals. And the translation of that is that you couldn't get specific, easy contracts from the government to make a ton of money off the federal government, unless you were a certain skin color or a certain gender. After a white woman sued, the court said the agency could no longer automatically presume racial minorities fit that definition. And the agency began requiring all applicants to document their disadvantage. Well, the cases are going pretty quickly and decisively against the government program, says Jason Schwartz, an attorney at Gibson Dunn, which has set up a DEI resource center and is handling a high-profile case against the Fearless Fund, a venture capital fund that offers grants to Black female entrepreneurs, and only to Black female entrepreneurs. Especially since the Harvard decision, Schwartz said, those government cases are harder to defend. Private companies, by contrast, have more legal leeway to implement diversity programs, attorneys said, and those cases have advanced more slowly. But a recent decision by the U.S. Court of Appeals for the 11th Circuit in the Fearless Fund case may be a harbinger of the challenges ahead for private sector diversity programs. Because the Fearless Fund lost big time. We covered that here on this channel. This month, the appeals panel blocked the firm from awarding its latest round of grants. The case, filed in August by a group led by Edward Bloom, the same activist responsible for the Harvard litigation that was successful, could have broad implications for other race-conscious initiatives in the private sector. The way their model was set up, as best as I can tell, is this, because they don't talk about the details at the Fearless Fund venture capital company. They would get donations from major companies, and then they would take chunks of 25 grand at a time and give it to Black female entrepreneurs. In exchange, I think, for nothing. I don't think they got ownership in the company for the 25 grand they were handing out. However, that relationship would then develop into they could go back to those companies and then offer them more money and then take a piece of their business. But the initial 25 grand that was put out as a grant to Black female entrepreneurs only would get them connected with that company. And that money was donated. That money came from Chase and other major companies, so they could say they were trying to help diverse entrepreneurs, which meant here's a company, the Fearless Fund, using money from other public companies to set up relationships where they were looking like a hero, giving out free money to Black female entrepreneurs, and then putting the Fearless Fund in a position to benefit from those donations financially by eventually becoming part owner in that company. And they could continue to do that with donations. They just can't do it based on skin color or gender. As long as they can get big public companies to give them free money to give away for their own financial benefit. That's what they have to figure out. Quote, this is the lifeblood of the civil rights movement, said Reverend Al Sharpton, a civil rights advocate following the case. If the Fearless Fund loses, we are the generation that lost what preceding generations provided for us. No, that is, of course, not true. If you know Al Sharpton, he has quite a checkered history. But aside from that, no one says that you have to discriminate against people based on their race, get free money from large corporations, and then profit off of it. If people need money and they have a business opportunity and you can help them and make a connection and big companies want to subsidize all that, they can do all that. You just can't do it based on race or skin color. The Harvard decision has so transformed the legal landscape that some companies are abandoning diversity programs as a defensive measure even before any litigation is filed. And why does a company do that? Because they know they're getting sued if they're going to do something illegal. Who knows how much trouble they'll get in? So what's the future of doing a program like that? There is no future. Lauren Hartz, an attorney at Jenner & Block, who advises companies with diversity, equity, and inclusion programs, said the litigation has had a chilling effect. Jenner & Block runs something called a diversity strike force team, something like that. And they're selling their legal services to companies that want to continue diversity, equity, and inclusion programs, even though they know they're probably illegal. So Lauren Hartz, Jenner & Block, they profit every time they can get a company to say, sure, we don't care, we'll get sued. Here's your legal fees and try to protect us as best you can. She goes on to say, quote, one lesson from the court decisions so far is that some of the qualities that can make DEI programs meaningful and effective, like specific targets, she means quotas, accountability and leadership, she means bonuses or firing people if you don't hire enough people of a certain race or skin color, and significant benefits reserved for the groups most in need, which are not the groups most in need. She's talking about judging people only not based on their circumstances in life, basing them on their skin color, gender, or sexual preference. She continues, are the same qualities that can make DEI programs more susceptible to legal challenge. Most companies would rather not be in the position of defending against the next major lawsuit, especially when everyone with any common sense legal or business experience knows this is completely illegal. It will come for every company that's doing this. George Floyd is not a defense. Most of the cases tracked by the Washington Post were funded by a dozen conservative legal groups, many of them regional nonprofits with relatively small budgets. The Milwaukee-based Will, for example, reported just $3.6 million in revenue in 2023, the most recent year for which information is available. America First Legal, which has cultivated a national profile, burst onto the scene in 2021 with a successful challenge to the Biden administration's debt relief program for minority farmers. But other groups have been around for years, including the Pacific Legal Foundation in Sacramento, the Foundation for Individual Rights and Expression in Philadelphia, and the National Center for Public Policy Research in Washington. Those groups have seen a steady uptick in financial contributions from donors eager to test the waters since President Donald Trump's appointment of 3 conservative Supreme Court justices. Between 2017 and 2022, funding to 10 of the most active groups nearly quadrupled from just over $35 million to more than $135 million, according to the Washington Post, analyzing their most recent financial disclosures. The flow of cash has helped finance legal operations that have locked onto an astonishing array of targets. In the past 3 years alone, lawsuits have been filed to undo racial preferences in awarding licenses for cannabis dispensaries in New York State. You're telling me, if you want to legally sell marijuana in New York State, you need to be a certain skin color? You're going to get preferences for a license for that? Of course that's wrong. Here's another one. Pursue employee complaints about diversity training sessions at a major cancer center in Washington State, public schools in Springfield, Missouri, and Honeywell, an international conglomerate. Here's another one. Abolish racial quotas for boards governing podiatric medical examiners in Tennessee, real estate appraisers in Alabama, a state bar association in New Jersey, and even companies listed on the NASDAQ stock exchange. And finally, eliminate racial preferences in fellowships intended for minorities at Pfizer, one of the world's largest pharmaceutical companies, similar fellowships at 3 nationally prominent law firms, and a nationwide physician partnership that offers incentives to Black physicians only. Many of the cases have yet to be decided, but lawyers are closely watching a handful of cases with potentially significant implications. A federal judge in Kentucky is expected to rule soon on whether to temporarily enjoin the U.S. Transportation Department from awarding contracts based on race under its Disadvantaged Business Enterprise Program, which received at least $37 billion under Biden's Infrastructure Investment and Jobs Act. And in May, the right-leaning U.S. Court of Appeals for the Fifth Circuit heard oral arguments in a case challenging a rule imposed by NASDAQ, which lists more than 3,000 public companies, including NVIDIA, Microsoft, and Apple. NASDAQ requires companies to include at least one diverse director on their boards or explain in their filings to the U.S. Securities and Exchange Commission why they do not. Under the rule, diverse means someone who identifies as female, an underrepresented minority, or LGBT. How about just having people on the board of directors that's qualified? I mean, whatever their skin color or their sexual preference is, or even their race, maybe their religion too. Just maybe people who are watching over the company and trying to make sure that management does the right thing by investors. Maybe they should just actually be qualified. And they can all be minorities. They can all be diverse. They can all be LGBT, however you want to define it. But they all have to be qualified. The National Center for Public Policy Research and Bloom's Alliance for Fair Board Recruitment challenged the rule in 2021, arguing that it amounts to a quota that the Securities and Exchange Commission was not authorized to approve. NASDAQ has defended the rule as a requirement for disclosure, not a mandate. The Fifth Circuit is expected to issue a decision in the coming months, especially because of the Chevron decision that rolled back the authority of these agencies unless there was a law that stated you needed to do this. For the SEC to come out and say, no, you kind of still need to do this, it's a regulation, we interpreted it this way, they're going to lose. They're going to lose big time. Scott Shepard, general counsel for the National Center, said he's confident his group will prevail, not just in the Fifth Circuit and not just before the Supreme Court, if the case makes it that far. To Shepard, the NASDAQ case is a small part of a much larger movement that is already reshaping society. Quote, it's gratifying to see Americans saying, no, the American ideal, the American experiment, is based on treating individuals as individuals and allowing each of them to rise to the level of their effort and their success and their merit and their possibilities. Quote, from our point of view, Shepard said, it's glorious. From Adam Post's point of view, it's also glorious. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.